Good afternoon to you. 406 now, News Talk 105.9 WMAL, where we're making sense of the news. Coming up, we're going to be joined by Julie Kelly at 4:30 with some important new reporting on how the FBI was prepared for an armed takedown of Donald Trump at Maralago. They were authorized to use deadly force. It's one of the craziest stories of the week, a week full of crazy stories. Andrew Clyde, the congressman, is here at 5 o'clock as the left fights this week to allow illegal immigrants to vote in elections in America. And you can join us at 888-630-9625, 888-630-WMAL.
Let me read for you the exchange between Todd Blanche and Michael Cohen. So you only gave him $20,000 and you took $30,000. Blanche, you stole from the Trump organization, right? Cohen says, yes, sir.
Yeah, big news this week that Michael Cohen admitting under oath on the stand in this trial that's supposed to be a criminal trial about Donald Trump. Instead, it sure seems like Michael Cohen is guilty of grand larceny and perhaps a lot more. For more on this subject, let's bring in Brianna Lyman. She's an elections correspondent at the Federalist, and she's on the phone. Hello, Brianna. Great to talk to you again.
Thanks for having me, Vince.
This seems like a big deal. Michael Cohen admitted to stealing at least $60,000 from President Trump's organization this week.
Yeah, it seems like Alvin Bragg has the wrong guy on trial right now because Michael Cohen should be the one, because not only did he steal $30,000, but when you gross it up essentially to account for taxes and other fees, it was $60,000.
Yes.
And this is information that absolutely hurts not only his credibility as a witness, but plays into the very real idea that this is political lawfare. Because when Alvin Bragg has on his plate an opportunity to prosecute someone for a higher charge, i.e. stealing from an organization, but chooses to prosecute someone on a lower crime by extending the statute of limitations, what else is an average American supposed to conclude?
Yes, that it's rigged and it's designed to only hurt Donald Trump. The prosecution built this case around the idea that, yeah, sure, Michael Cohen was a liar, but all of his lies were told in the service of Donald Trump. This revelation demonstrates that's not true, is it, Brianna?
No, not at all. And it's funny that the mainstream media, the way that they've reacted to this is that you had the New York Times, MSNBC saying that Michael Cohen's past lies and his current lie actually make him super credible. So we should trust that a man who stole $30,000, admitted it on the stand, is actually still a star witness because he could apparently, get this case into a guilty verdict. And when it comes to Michael Cohen, this is somebody who all the defense really has to do is convince the jury that anything he says is untrue. And the only thing that he said that I think they should take as truth is when he admitted that Donald Trump's initial reaction to the whole Stormy Daniels story and alleged affair is that Donald Trump did not want his family to find out about it. And Vince, the reason that is so important is because this entire case hinges on the premise that Donald Trump had this story covered up to impact the election. But if Michael Cohen is saying that it was done because he wanted his family not to hear about it, seems like Alvin Bragg doesn't have a case.
No, he doesn't. So is it, there's the question now is, could Michael Cohen be charged with a crime? Is, in light of the fact that he admitted to one, we saw some claims this week from attorneys that apparently in New York State, if once fraud is discovered, that is the beginning of a 2-year statute of limitations. Michael Cohen could be in some legal trouble here, right?
You would hope so, and you have to wonder, did Alvin Bragg know about this prior to bringing the charges against Donald Trump? Because if he did, again, it leads credence to the idea that Alvin Bragg is a politically motivated prosecutor, because if he was made aware of a potential felony and said to Michael Cohen, well, I'm not going to charge you if you testify against Donald Trump, that just shows how shoddy this entire, lawfare trial has become and is.
Yes, that's for sure. That's for sure. So talk about the judge's behavior here. The judge has gone, it seems like, over the top to stop Donald Trump's team from being able to present important information to the jury. But he's allowed people like Stormy Daniels to come in and sexualize a bookkeeping trial. What do you make of Judge Merchan's behavior throughout all of this?
Well, this is someone, again, he has been asked to recuse himself on multiple occasions, and he should have. If someone cares about the law the way he claims he does and the sanctity of the justice system, then he should have removed himself so that there would be no room to doubt whether or not he was involved in this for partisan purposes. And when you bring up the fact that, he donated to Joe Biden, his daughter's biggest client is Adam Schiff, and he's prohibited Donald Trump from saying true and factual statements, it again allows individuals who are independent voters to say this has political undertones. And if Alvin Bragg and Judge Juan Merchan didn't want that to be the overcast of the entire case, they should have recused the judge, and Alvin Bragg should have never brought these charges in the first place.
I mean, do you think it's obvious to most people that this is nothing more than election interference on the part of the left?
Absolutely. And I think Donald Trump is fortunate that this is the case that came first because it was the weakest out of all four cases presented against him. And so whether or not he's found guilty or not guilty, I think the public will see a guilty charge as a improperly functioning jury, especially given the fact that you have CNN analysts saying that this is a nothing case, that, Michael Cohen essentially perjured himself. He kind of, torpedoed the case. So when you have bipartisan condemnation of how the case is brought and is being handled, you have to hope that independent voters are kind of reading both sides of the aisle and getting the same consensus.
Well, it does seem like, as you stare at the polling on all of this, that the American public is walking away with the impression that this is a hatchet job, that this isn't any way the fair administration of justice.
Yeah, absolutely. And they're also going to get that for the other cases. I mean, I know you're having Julie Kelly on soon, and she'll talk about this more, but when you talk about the other cases, especially the Maralago classified documents case, the Department of Justice admits, for instance, that they tampered with evidence, right? They had FBI agents on guard to potentially take down Donald Trump with weapons. And so when you hear these things, it doesn't scream justice system. It screams Biden's top Department of Justice officials have their hands in everything.
Yeah, it's super dangerous. Okay, so just in terms of predictions, do you think that they are going to score a conviction next week, regardless of all of the insurmountable evidence that this is, again, a hatchet job?
I'd hope not, because there's two lawyers on the case right now, and I actually just served jury duty last week, and I found that had I not been there, a lot of my peers would have convicted this individual when there was not enough evidence to do so, even though we all agreed he seemed like a shady guy.
Yeah.
With two lawyers on the case, you have to hope that they will say, this evidence doesn't count, or this evidence, for instance, doesn't actually prove intent, which is going to be the key to proving Donald Trump guilty.
Yeah, but yesterday the judge turned down the defense's request to bring an expert witness in who could say that none of this ran afoul of election law, and the judge said, "Oh no, you can't do that. I'll talk about the law with the jury."
Yeah, and it's unfortunate because jurors are not allowed to take into account someone not testifying. So Donald Trump not testifying, they can't take that into account. And I'm sure the judge will say you can't take into account me saying that an expert can't testify to you. But I think that they should keep that in the back of their mind. Why is someone who's partisan, before they even were picked for jury duty, they knew his partisan beliefs? Why is he not letting an expert testify? If it's the same law that Judge Juan Merchan is going to talk about, he should have been allowed to get up there and speak.
It's really remarkable what's happening. All right, Brianna Lyman over at the Federalist, thank you very much for your time today. Really, really appreciate it as always. Thank you.
Thanks, Ben.
All right, that's Brianna Lyman over at the Federalist, and yeah, there's no question here. This is just an insane effort of election meddling. The election expert was Brad Smith, and there's a piece today in the Washington Examiner by Byron York. And he quotes Brad Smith here. It's what I would have told the Trump jury. And here's what he said. In recent days, it has become clear that the Trump trial, in which Manhattan District Attorney Alvin Bragg seeks to imprison former President Donald Trump for a maximum of 136 years over allegedly false bookkeeping, will somehow come down to federal campaign finance law. In this way, Trump is charged with falsifying his company's business records regarding his payment for a legal non-disclosure agreement with the porn actress Stormy Daniels, and doing so with the intention of committing another crime. But prosecutors have never specified what the other crime is. In various court filings, however, prosecutors have suggested they plan to argue that Trump intended, along with the false bookkeeping, to violate a state law that bars promoting a political candidacy by, quote, unlawful means. That's the other crime, prosecutors will say. And the unlawful means will be a violation of the Federal Election Campaign Act, FECA, the 1970s-era law that regulates political fundraising and spending in federal elections. This is all Byron York, by the way. I said I was quoting Brad Smith. He gets to Brad Smith here and talking about how Smith is telling Byron York that he wanted to basically make this testimony, but was not allowed to by the judge. He says Smith was not going to give the jury his views on the specific charge against Trump. He knew the judge would never allow that, and he didn't intend to try. Instead, had he been allowed, Smith said he wanted the jury to know about the complexity of campaign law. Quote, judges instruct the juries on the law, Smith said, and they don't want a battle of competing experts saying here's what the law is. They feel it's their province to make that determination. The problem, of course, is that campaign finance law is extremely complex, and just reading the statute to people isn't really going to help them very much. Smith gave the example of a product liability lawsuit over a complicated piece of machinery. Quote, and you just said to the jury, they're guilty if you find them negligent. Well, what is negligence? Negligence is not using ordinary due care, and the jury has no idea of what is technologically feasible. What are the industry norms? How do people understand it? And that sort of thing. In this case, FICA is a very complicated piece of machinery. The goal of his hoped-for testimony, Smith said, was to, quote, lay out the ways the law has been interpreted in ways that might not be obvious. As an example, Smith cited the phrase, quote, for the purpose of influencing an election, end quote, which has been heard during much of the analysis of the trial. Quote, you read the law and it says that anything intended for the purpose of influencing an election is a contribution or an expenditure, Smith explained. But that's not, in fact, the entirety of the law. There is the obscure and separate from the definitional part idea of personal use, which is a separate part of the law that says you can't divert campaign funds to personal use. That has a number of specific prohibitions, like you can't buy a country club membership. You can't normally pay yourself a salary or living expenses. You can't go on vacation, all these kinds of things. And then it includes a broader general prohibition that says you can't divert campaign funds to any obligation that would exist even if you were not running for office. What is the point of that? Byron asks. Smith replies, we would have liked to flag that exception for the jury and talk a little bit about what it means. And also, we would have talked about, quote, for the purpose of influencing an election is not a subjective test like, what was my intention? It's an objective test. So hiring campaign staff is for the purpose of influencing an election. Renting space for your campaign office, buying ads, maybe doing polling, printing up bumper stickers, traveling to campaign rallies, renting venues for campaign rallies. All of those things exist only because you are running for office. But under the personal use rules, a lot of things candidates do running for office are not considered campaign expenditures. Things like paying for a weight loss program or a gym membership, nicer clothes, teeth whitening, or all that sort of thing. It may be true that you do those things in part to help yourself get elected. You might not do them otherwise, but they're not obligations that exist simply because you are running for office. Lots of people do those things. When it comes to the details of the Trump prosecution, knowing how campaign finance law works has led Smith to believe that what is alleged to be the core violation in the case, that paying Daniels amounted to a campaign contribution or a campaign expenditure, is simply not true. Quote, I can tell you my personal belief is that clearly paying hush money or paying for a non-disclosure agreement does not constitute a campaign expense, Smith said. To use an example I've often used, it's not a campaign expense if a business person is running for office and his businesses are getting sued, and if he goes to his company lawyers and says, I want to settle those lawsuits against us. We've got some wage employment lawsuits, and a woman is alleging sexual harassment. We've got 36,000 employees, but we've got these 3 complaints, and the press will make a big deal about them. So I want you to settle these. And the company's lawyers say, no, these are great cases. We should win. We shouldn't settle them. And he says, I don't care. I'm running for office. I don't want press stories on it. I want you to settle them quietly. Well, he cannot use campaign funds to pay that settlement, even though he's clearly doing it for the purpose of influencing his campaign. It's kind of similar to what went on here, Smith said. So my personal belief is that this case would not have been a campaign expenditure, never had to be reported, and therefore was not misreported. Because remember, the money doesn't come, obviously, it doesn't come from, this is Vince speaking, it doesn't come from campaign funds. It came from the Trump organization. It came from Trump. These were not donor funds that were allocated toward this. Now, if it was Hillary Clinton spending campaign donor funds to gin up a fake dossier on Donald Trump and then calling it legal expenses, Alvin Bragg would have a case. Because that actually happened. Unlike this, which is not a case at all. So the expert witness was prevented from testifying to how the law actually works by a judge who did he donate to in 2020? Oh, that was Joe Biden. The judge is a Biden donor. All right, coming up in a few short minutes, we're going to be joined by the excellent Julie Kelly. Some breaking news today. Unsealed filings in the classified documents case involving the left's many efforts to take down President Trump. It turns out the FBI authorized the use of deadly force at Maralago and apparently had all sorts of plans in place in case President Trump showed up during the raid. We'll get the latest from Julie Kelly on that subject. But before we get there, our friend Greg Price posted this to X in the last few minutes. This is a flashback. This is Merrick Garland telling the public that he personally approved the raid on Maralago. So all of the contours here, the idea that deadly force was authorized to go after the former president of the United States, this was all signed off by Joe Biden and, more specifically, Joe Biden's Department of Justice, Merrick Garland. Take a listen.
There are, however, certain points I want you to know. First, I personally approved the decision to seek a search warrant in this matter. Second, the department does not take such a decision lightly.
Okay, so there he goes. He personally approved the raid on Mar-a-Lago. And Julie Kelly has a bunch of really provocative details here. Law enforcement officers of the Department of Justice were advised they may use deadly force when necessary. Those armed FBI agents were apparently prepared to confront Trump and even engage Secret Service if necessary. They were also going to go door to door to, in Julie's words, terrorize Mar-a-Lago guests and even pick the locks. They were prepared to pick all of the locks on the hotel rooms there at Mar-a-Lago, I guess country club rooms, whatever you might call them, as guests stay there. Really, again, another jaw-dropper today, these developments. Julie Kelly will give us all of it just moments from now when she joins us here on the Vince Coglianese Show. Buckle up. Another big story coming at you. Hey, good afternoon to you. 4:34 here on News Talk 105.9 WMAL, where we're making sense of the news. Coming up, Congressman Andrew Clyde will talk to us about the left's latest efforts to try and allow illegal immigrants to vote in our elections. Republicans in Congress trying to stop that. We'll discuss with Congressman Andrew Clyde. You can join us at 888-630-9625, 888-630-WMAL. We keep finding out more and more about that August 2022 raid of President Donald Trump's Mar-a-Lago by the Biden administration. All sorts of shenanigans there, including the FBI bringing props with them to the, quote, crime scene in order to create even more drama as the public began consuming what went down. Now we find out that the FBI apparently authorized the use of deadly force for that raid. Nothing like that's ever happened in American history. Deadly force against the former president of the United States. For more on this, Julie Kelly joins us. She's breaking this news today. She's the author of the Declassified by Julie Kelly Substack and the book January 6th, How Democrats Used the Capitol Protest to Launch a War on Terror Against the Political Right. Julie, thank you for your time as always.
Oh, always. Thanks for having me on, Vince.
Julie, what is happening here? You have documents unsealed today in court proceedings. What do they reveal?
Yeah, so this is happening fast and furious. There were a bunch of unsealed motions docketed today in the classified documents case in Southern Florida. As you know, and we've talked about Judge Aileen Cannon on this transparency and accountability crusade. God bless her. Thank you for this, Judge Cannon. So really important motions docketed today by Donald Trump. Basically what the motion was is to suppress the evidence from the Mar-a-Lago raid, calling it unlawful, that the agents misled the court as to the necessity for the raid. But then looking through the exhibits, there is this shocking operations order that the FBI law enforcement prepared on August 3rd of 2022. The raid was on the 8th. And part of that order is an explanation of the use of deadly force and what agents must abide by if they're confronted with a situation where deadly force would be necessary. Just completely shocking, but there are other details too that underscore, how really not just unprecedented, but how dangerous this raid really was. And parts of it talking about how agents should conduct themselves if Donald Trump appeared at Mar-a-Lago. Of course, he was at his home in Bedminster, summer home in New Jersey. But if he did show up or there was a confrontation or resistance with Secret Service agents, then advising the agents on the ground how to respond. Just really stunning, mind-blowing revelations that you just can't believe this is happening in America.
I mean, you would think that, in the event that federal law enforcement's going to a location like Mar-a-Lago, that they would ahead of time talk to Secret Service and deconflict anything like this. But instead, they apparently wanted to surprise Secret Service, so they saw themselves at odds with the Secret Service here?
Well, there's some dispute in this particular document, Vince, that they were in correspondence with the Secret Service prior to this raid, but then talks about, how to handle if there was resistance by the Secret Service. So not really sure how they plotted that out. But even aside from that, more unusual aspects of this, you had one of DOJ's top officials with counterintelligence unit who participated in this raid. You had the assistant U.S. attorney for the Southern District of Florida. Prosecutors don't show up at raids. They're not investigators. They're prosecutors. Then you had 4 agents out of the Washington FBI field office and an official from the FBI headquarters. There was nothing normal about this raid. And then there's more documentation, aside from the use of deadly force, that agents were armed. They brought bolt cutters. They talked about picking the locks at Mar-a-Lago guest rooms if staff did not turn over keys. What possibly would they need to look at Mar-a-Lago guest rooms for? They ransacked Melania's room. They took pictures. They ransacked Barron's room. This was not, we need national security files, to keep the country safe. This just again underscores what an egregious, corrupt, dirty investigation this has been since the very beginning. And again, thank you, Judge Cannon, for allowing the American people to see all of this material.
Yeah, this is really stunning. Now, if I'm anticipating an FBI reaction to this, to the extent that we'll get one at all, I assume they're going to say something, this is standard practice. Being prepared for an armed conflict is standard practice. This is over the top. This is the former president of the United States. You were prepared for a shootout with the Secret Service to go and raid Mar-a-Lago? This is insanity.
Yeah, I've already seen a few former FBI agents, Vince, people who I thought were, skeptical of the FBI saying, no, this is standard operating procedure. There's always an explanation or a form related to the use of deadly force. No, this is not normal. You don't storm in Mar-a-Lago when the president, his lawyer, and his team have been cooperating with the DOJ and FBI and the archives for more than a year and a half at that point. I mean, Donald Trump let Jay Bratt, the head of counterintelligence DOJ, and 3 FBI agents voluntarily allow them into Mar-a-Lago in June of 2022. There was no reason for an armed raid with dozens of agents for 9 hours ransacking the former president's home that could have resulted, now we know, in something that could have been fatal, and who knows? So, your imagination can run a little bit wild here with the different scenarios, but the bottom line is none of this had to happen. None of it should have happened. Attorney General Merrick Garland is the one responsible for this. He bragged how he personally signed up on this raid.
Yes.
And the various elements of it that we're learning about now.
Yes, and you don't do that as the Attorney General of the United States without the blessing of the White House. Can you talk about the political involvement of Joe Biden and the White House counsel's office throughout all of this? They keep on suggesting that there is no political interference here, but my understanding throughout all of this is Biden and the White House counsel's office was very much involved in waiving Donald Trump's executive privilege rights and helping usher along this raid on Mar-a-Lago.
Right. So Joe Biden took the extraordinary step, this has never happened in U.S. history, of denying privilege claims of his predecessor. No president has ever done that. to his predecessor before. Joe Biden did it a number of times, beginning with denying Trump's executive privilege claims to keep presidential files from the J6 committee.
Right.
That kind of started it. But the other revelations we're getting out of the unsealing and unredacting of these documents in southern Florida is evidence of close collusion between the National Archives, the Department of Justice, and to your point, Joe Biden's White House counsel. These are his top attorneys. They work in the West Wing. It's not like they're scuttled somewhere else in a law firm building in downtown Washington. They are the president's closest legal advisors. So the idea that now we have evidence of phone calls, of emails, of meetings between archive officials and Jonathan Sue, Biden's deputy counsel at the time, Dana Remus, who was his general counsel at the time. And this is what Donald Trump, again, in this filing today, and there's so much happening. If people can check out Julie_Kelly too on Twitter and X, where I've been posting this. Donald Trump said the day of Joe Biden's inauguration, the archivist, David Ferrero, who's an Obama appointee, started working right away with another longtime White House employee, probably with the Records Management Office, to concoct and manufacture some sort of documents crime or case against Donald Trump. That was the filing, another revelation today in one of these motions.
It's just remarkable. So where does that leave the actual court proceeding? Judge Eileen Cannon has expressed the proper skepticism of the Biden administration's case here. And I know there's a bunch of pretrial motions involved. Where is this headed?
Well, it's headed, as I've explained. Judge Cannon is basically starting tomorrow, and I will be in the Florida courthouse tomorrow. Starting tomorrow, she's basically turning the tables on Jack Smith and DOJ and putting them on a trial of sorts. So tomorrow will be a public hearing on Walt Nauta, who is Trump's longtime aide and a co-defendant here, his motion to dismiss for vindictive and selective prosecution. That should produce some fireworks. Mm-hmm. And then in the afternoon, there'll be another hearing on all of the defense motions, including Donald Trump's motion to dismiss the indictment, based on many of the falsehoods and vagueness of that indictment. And that indictment, I will tell you, Judge Cannon also is not a fan of. She often kind of makes derisive comments about how it's a speaking indictment. And, prosecutor, lawyer, you went on and on and on in your indictment about this. So I'm really interested to see how this will all unfold, and she will have more hearings next month related to the collusion with the Biden White House. So
how much will Robert Hur's report turning down charges for Joe Biden after he stole classified documents as both a United States Senator and a vice president, how much will that report play into Judge Cannon's thinking, especially as it relates to selective prosecution?
Well, I was at the courthouse 2 days after Robert Hur testified to Congress about why he declined to bring charges, but then, of course, exposed all the evidence related to what Joe Biden did, in many instances worse than Donald Trump. She many times brought up the Hur report and his testimony, asking Jack Smith's chief counsel, Jay Bratt, why is this the first time that the government is bringing charges for such conduct? No other president or vice president has ever been charged. Why is this case different? So she was really hinting that she will very strongly consider selective prosecution motions to dismiss. But she has a lot of, part of me even thinks she wants to continue with this because it's the only way to make public the dirtiness, the corruption, the sloppiness, the vindictiveness, and now really the danger of this investigation and prosecution from the start.
Yeah, and the thing has been so brazen. I mean, just the revelations in the last few weeks that you and I have talked about, where the FBI has mishandled the evidence such that they've actually jumbled up the paperwork that they retrieved from Maralago, thus disturbing the evidence, not having it retained in the way that it was found. Additionally, the revelation that they brought these props with them, these so-called classified cover sheets, and then spread them out on the floor, took photos of them, disseminated them to the public as if that's how they found these documents at Mar-a-Lago, when in fact the FBI brought the very props that were seen in the photographs.
Exactly right. I know we talked about this too. That's on my Substack if people want to check that out. But also the confession by Jack Smith that, to your point, evidence is not in the same order and sequence as it was after the raid. The big issue there, though, is that Jay Bratt, Jack Smith's prosecutor, told Judge Cannon last month in a hearing, again, I was there and heard it, she directly asked, because of course she knows all of this, right? But she wants the government on the record about their lies. She specifically asked Jay Bratt, is all the evidence in the same original form that it was after the raid? And he said, oh, yes, it is, with the exception of classified papers were taken out, and we put a cover sheet as a placeholder in that box. That's not what happened. And Jack Smith had to come back and tell Judge Cannon and everyone else that that's not true, that there are hundreds of papers in between some of these files, the sequence that the FBI investigators gave the defense. In some cases, Vince, Jack Smith further said, the placeholder that they use for a classified document, they can't match up that sheet with the actual classified document that they took out of the box. So this case is imploding right in Jack Smith's face. But now the dirty fingerprints, again, of Merrick Garland, Christopher Wray, Stephen D'Antuono, who headed up the Washington field office and really oversaw the elements of this raid. For Americans now to sit here and think that armed FBI agents had authority and guidance as to how to use deadly force at Mar-a-Lago, it's just mind-blowing stuff.
It's so over the top and so tyrannical. Finally, Julie Kelly, when you're sitting in that courtroom and you're watching these proceedings, do you ever get angry glances from Jack Smith's team? They ever look over and they go, there's that dastardly Julie Kelly covering all of our behavior again?
Well, I'll tell you what, I usually stay in the media overflow room because you can really see and hear everything. I think I get a few dirty looks from reporters, but I will say most of them are very pleasant and fine. But, unfortunately, I haven't had a chance to confront Jack Smith or Jay Bratt and, give them my famous stink eye, Vince.
Yeah.
Hopefully the time will come.
That time will present itself, I'm certain. All right. As always, Julie Kelly doing such excellent work and sharing this important breaking news today. Julie, good to talk to you. Thank you so much. Okay, President Trump stepping up to the microphone just moments ago outside of that New York City courthouse yet again. Let's take you to some of that audio right now.
Thank you very much. Jonathan Turley just came out with a statement that he thinks that this case is collapsing of its own weight. This case is a disgrace to our country, to the state of New York. Never seen anything like it. Stephen Calabresi, it's an outrage that the district attorney brought this case and that the judge did not declare it a mistrial. Very highly respected. Stephen Calabresi. He says an outrage that the district attorney brought this case and the judge did not declare a mistrial. And everybody's saying it in one form or another. Andy McCarthy. What they have, this kind of a case, is that the federal prosecutors at my old office, the Southern District of New York, wouldn't take it in the first place. They would not take it. The Southern District turned down this case. And the case that Cy Vance looked at and wouldn't take it, and the case that Bragg himself looked at in 2022 and shut it down. And this is what we've been wasting all this time on. Alan Dershowitz, I've observed and participated in trials throughout the world. I have seen justice and injustice in China, Russia, Ukraine, England, France, Italy, Israel, as well as in nearly 40 or 50 states. But in my 60 years as a lawyer and law professor, I have never seen a spectacle such as the one I observed sitting in the front row of the courthouse. I've never seen anything like it. He's been a great lawyer, great legal scholar for years. He's never seen anything like it. It's all politics, said Leo Terrell. If anyone tells you otherwise, they're not a lawyer. Let me just tell you that the White House is the person or the group, whatever. They're the one trying this case. You heard who was doing all the talking. Representative from the White House just recently. This is all about Biden can't campaign, so he's trying to injure his opponent. They're trying to hurt the opponent because they can't win it fair and square. It's lawfare. There are a lot of terms for it. It's a third world country way of campaigning. Such a disgrace. So sad to see what's happened to our country. Our country's going to hell under Biden. But look at the person. Why don't you look at the person that argued their case, almost the entire case? Look at the person. Where did he come from?
That's Matthew Colangelo he's referring to. Number 3 over the United States Department of Justice, now in Alvin Bragg's office, trying to stop Trump from becoming president again. Joining us next, Congressman Andrew Clyde. He was just with President Trump this week, and he's trying to stop Democrats from letting illegals vote in our elections. Democrats, well, you know what they're fighting for.